Good afternoon, everyone. Welcome to the special Legal 500 webinar titled Emerging Challenges in Global Competition Law Enforcement, Hot Topics in the Near Future. This webinar focuses on the future challenges in global competition law enforcement, and will cover a number of hot topics, including food security, inflation, and competition law enforcement. The speakers will also address the relationship between competition law and sustainability. They will also unpack and address the question, is there a monopoly problem in digital markets? Other topics discussed will be globalization and its relation to competition law, including convergence versus national policy preferences. The speakers will also delve into the interface between public interest goals and the prime objectives of competition law. Today, we are happy to be joined by three leading experts in the field of global competition law enforcement. Gönenç Gürkaynak is the founding partner of ELIG Gürkaynak Attorneys at Law, a leading Turkish law firm of 98 lawyers based in Istanbul. Gürkaynak graduated from Ankara University Faculty of Law and was called to the Istanbul Bar in 1998. He also received his LLM degree from Harvard Law School and is qualified to practice in Istanbul, New York, Brussels, and England and Wales. He also leads the competition law and regulatory department of ELIG Gürkaynak Attorneys at Law, frequently representing multinationals and domestic clients before the Turkish Competition Authority. Additionally, he's quite prolific, having published more than 200 articles in English and Turkish. He also holds teaching positions at 2 Turkish universities. I'd also like to introduce Eleanor M. Professor of Law and Walter J. Derenberg Professor of Trade Regulation at New York University School of Law. She is an expert in antitrust law, competition policy, and globalization issues. She is especially strong regarding matters involving developing countries, the connections between equality and efficiency in trade and competition. She was previously a partner at New York-based law firm Simpson Thacher and Bartlett, and from 1997 to 2000 served as a member of the International Competition Policy Advisory Committee to the Attorney General of the U.S. Department of Justice. Additionally, she has advised a wide range of jurisdictions regarding antitrust law, including South Africa, Egypt, Kenya, Tanzania, and Indonesia, amongst many others. She has also authored numerous articles and co-authored US and EU competition law casebooks. And lastly is Frédéric Jenny, Emeritus Professor at ESSEC Business School in Paris, and is Hauser Global Professor of Antitrust at NYU Law School. He's also chairman of the OECD Competition Committee. He has especially experience regarding trade, competition, and economic development, and served as an advisor to developing countries on competition and trade matters. He also has an impressive resume, including acting as a judge on the French Supreme Court from 2004 to 2012, vice chair of the French Competition Authority from 1993 to 2004, and president of the WTO Working Group on Trade and Competition. He's also been a visiting professor at several universities, including Keio University Department of Economics in Japan, University of Cape Town Business School in South Africa, and Haifa University School of Law in Israel. In summary, I think we're in for an exciting conversation from 3 experts in global competition law, and I'm excited to learn a great deal from them. So passing on to Gürkaynak, really appreciate you all listening to me go on about 3 of you.
Thank you, Nathan. Very, very kind of you. I'm sure the audience is interested to know what Fred and Eleanor have to say about these topics. I'll try to facilitate, and sometimes I'll try to also interject my own remarks. But first, for the audience to know, these topics, the 5 topics that we have selected, are selected freely by us, basically concentrating on what is cutting edge and interesting and topical in the competition law world right at this moment. So when we're discussing food security, inflation, and competition law enforcement, it's not going to be by luck that we're choosing this topic. We discussed among ourselves that, you know, these are pressing topics. There's the Russia-Ukraine matter. It is creating food security issues. Also, obviously, a very significant and disturbing human drama. The inflation is high in very many nations at the same time. For quite some decades, we haven't seen this kind of an economic phenomena. And could there be anything for competition law to do? This is obviously with a perspective to make sure that we are focusing on the objectives of competition law properly and making sure that competition law is not hijacked for other purposes, but at the same time, we're not underperforming if there is something competition law can really do. So let's start with that topic, and let me turn it over to Fred, who proposed this particular heading, and I know that it's particularly close to his heart. So Fred, what would you like to contribute on this particular topic?
Well, I would like to answer one of the questions that you raised, which is what is it that competition authorities can do? And I want to point out the fact that I think that indeed there hasn't been much action on the part, at least of the EU Commission, on an issue which is quite important, raises all the things that you've mentioned. Now, it may be that competition authorities have been so busy with digital issues that they have a little bit forgotten about the more pedestrian cartels. Okay, so what I want to talk about is briefly is potash, because among the things that we know is the fact that it's a mineral rich in potassium, which is one of the 3 essential nutrients for crop. Okay. Now, what happened in the potash is, just to give you an idea of the structure, there are 3 main producers of potash in the world: Belarus and Russia on one side, and Canada on the other side. I mean, there are a few other producers, but much less important. Canada plus Russia plus Belarus produce about 70% of the potash in the world. Second, potash is used by every country in the world which produces grains, which grows wheat, grows maize, corn, or barley, or any of those. So it is very widely used throughout the world. And most countries either do not have a deposit, or if they do have a deposit, they have a deposit which is largely insufficient to cover their needs, so they need to import either from Eastern Europe or from Canada. Now, we know that several things have happened. First, in December 2021, when the US imposed sanctions on Belarus, and then after that in March 2022, when, because of the Ukraine invasion, there were restrictions which were imposed on the exports from Russia and Belarus. So the result is that the only source of potash now for the European Union, which used to import most of its need in potash from Eastern Europe, is Canada. So we've switched to Canada. Now, in Canada, there used to be 3 producers, and now there are 2, because 2 of them, Potash Corp and Mosaic, merged into a new firm called Nutrient. So there's only one independent firm besides Nutrient, and those firms act in an international cartel. In other words, they will not compete on either quantity or price between themselves, and they have a joint selling agency, which is called Canpotex, and which handles all the exports from Canada. Now, this is a bit of a problem because, of course, recently there was some competition between the Eastern European producers and the Canadian producers, and this has gone by the wayside. Now we are faced with an export cartel, and there's nothing, no source of competition that can be brought into the proceedings. So what is the question? Well, the question is, it's interesting because we have had a natural experiment in potash, because around 2006 and 2007, the producers of potash eliminated competition among them. In other words, the Eastern Europeans got together with the Canadians and said that they were going to act together on prices and quantity. And what they did was they restricted quantity and they increased prices. And the prices at the time went from something like $200 a ton to above $800 a ton. So we know that by acting together, they can increase considerably the price of potash, and they can restrict output, which is exactly what is taking place right now, where the price of potash, and I remind you that the only source is the Canadian export cartel, has gone from last year to this year from something around $400 to a ton to above $1,000 a ton. So there's considerable increase in the price of potash, with the result, of course, that farmers have a lot of difficulty securing potash and that it becomes very expensive for them. And the natural result, of course, is a reduction in the quantity of potash which is put in the ground, and with it, a considerable reduction in the productivity of agriculture, which is basically divided by two. Now, what is quite extraordinary about this is that we know how the cartel works. We know what is the impact of the cartel. We know that it increases the price of food. And we know that this is an illegal cartel. If I take the EU law, it's something illegal to do this in the EU. And one wonders really why it is that the European Commission has not opened an investigation on this cartel, for several reasons. One of them is that it's very public, so there's no difficulty in finding information about it. Second, it's clearly having a massive effect in Europe, as it is having a massive effect, by the way, in the rest of the world and also in developing countries, by increasing the price of foodstuff and the price of, and reducing the productivity of the land. And we also have declarations by the head of the Canadian firm saying that they have extra capacity, but they are not going to use this extra capacity except for 1 million ton this year because they want to make sure that the prices stay high. Now, this is an international cartel which has direct effect in the European community, which is a direct violation of law, and which is creating a lot of hardship for people. So it's a bit difficult to understand why it is that a large competition authority would not immediately go after that and force the Canadians to compete for the business of the Europeans. And it does tell us something about the fact that competition authorities have not solved the problem of international cartel. I mean, even though, I add, the Europeans and the Canadians have a 1999 cooperation agreement with a provision that says that if one country requests the other one to provide information about a cartel, the other one will do it as long as it is not contrary to its domestic laws and that it is in sync with its interests. It's very clear that those cooperation provisions are insufficient to solve the problem. And it may be the case that competition authorities have been too focused on much fancier cases, such as the digital cases, and I've forgotten about the fact that they can be very useful in slowing down the increase in fertilizers and slowing down the increase in foodstuff, which has huge implications, not only in the EU, but also in the Mediterranean region, where a lot of countries depend on the production of grain and wheat for their foodstuff. So I wanted to point out that there are cartels out there that wait to be sanctioned and that competition authorities seem not to be all that interested in them.
This is extremely interesting, very specific, very targeted, very direct. There's no doubt that what has been said is squarely falling in the gambit of competition law enforcement. You know, when one looks at the heading of food security, inflation, and competition law enforcement, one could actually speculate or think for a minute that probably there's going to be some form of price-related enforcement being advised, or are they going to you know, dilute the approach of a pure competition law enforcement? But then Fred has talked about a cartel. Whether it exists or not is to be identified by competition authorities. But that's the invitation, and it's a very clear invitation. One question, Fred, to stay on this point, so that I'm not, you know, gliding through something very significant too quickly. So there is the Comprehensive Economic and Trade Agreement, the CETA, between Canada and the EU. There is the 1999 Cooperation Agreement between the Canadian Competition Bureau and the Commission in the EU. And yet the EU Commission seems to be not prioritizing this at the moment. You're thinking it's possible that because they're not as concentrated on quintessential real industry markets anymore, and they're doing a little too much of a detour in digital. But one question, do you believe that the effects are so squarely born outside of Canada that the Canadian Competition Bureau and Matthew Boswell couldn't take on a case like this?
Yes, because it is a joint export agency of the only two large producers in Canada. But so it only applies to export. Okay.
Correct.
So it doesn't have any implication domestically, except in a very indirect way. In a very indirect way.
But if export is so artificially profitable, it will no doubt mean that it is hitting the domestic market as well.
Absolutely.
They could in an indirect way. If they wanted.
But there is, I think, another consideration that one has in mind, which is the fact that the states of Canada get a lot of money for every ton of potash which is mined in the country. And as a matter of fact, but a couple of weeks ago, the state of Saskatchewan, which is where there is most of the mining being done, has predicted publicly that its revenue from potash extraction will increase from 400 million in 2021 to 1.5 billion in 2022. So I think there are huge interests in Canada not to do anything about this export cartel. Now, my contention is that one doesn't need, the EU Commission probably doesn't need much help from the Canadian government, because all of this is very public.
Yeah. Switching to Eleanor, I'm going to take all of you back 21 years to year 2001. When while I was getting my degree at Harvard Law School, my then girlfriend, now wife, Sarah, was doing her studies at New York University. And she was lucky to be a student to Eleanor. And when I was auditing Eleanor's courses, which I was religiously doing, so I was really doing a back and forth between New York and Harvard, always getting into all of Eleanor's courses, I very vividly remember that in one of the courses, she said, OPEC is a cartel. And I was quite taken aback by it, not in a negative way, but I was thinking, wow, what academic freedom, and how wonderful is it that, you know, a professor can just direct her attention to something this big and say what it is. Fred has done a version of that. And that reminds me of that conversation, which is, are certain cartels too international and too big to fall into the hearing ability of certain authorities? Could we be dealing with a situation where certain antitrust agencies are really backing down because they feel the target is too big or too widespread. It's not within their bandwidth of hearing. Is that at all possible, do you think, Eleanor?
Oh, so that's a very interesting question. However, OPEC, of course, is a cartel. I mean, it's a notorious cartel, just like Potash is a notorious cartel in Canada. Of course, OPEC is mostly owned by a number of oil-producing nations, but it's doing business. It is commercial. It should not be under sovereign immunity. And yet the countries, the enforcing countries of the world have been shy to sue the members of the OPEC cartel. They ought to. My colleague Harry First just had an op-ed in the New York Times this past week saying the countries, US ought to sue OPEC, and in particular, we have a bill pending in our US Congress, which is called NOPEC, no oil producing cartel, which would allow the government to sue. Obviously, it has very many political sensitivities, but potash, I mean, a fertilizer and oil are two of the biggest culprits in our overheated economy with overheated inflation. And oil is scarce, we need it. The prices of oil have gone up extraordinarily. It is, I would say, so easy. Obviously, this is politically nuanced, but it is so easy to sue the commercial members of this cartel. And if they were sued, the price of oil would go down.
Very interesting.
Can I have just one thing? Of course, one of the differences is the fact that the Potash cartel is a private cartel. It's not a cartel of governments as OPEC. Second, I don't want to put the onus too much on the EU because, for example, the US Department of Agriculture has put out in March a communique saying that there was going to be a very difficult situation, in particular, because there was no competition on the fertilizer market. So the US, even though the cartel does not directly operate in the US, is also possibly a victim of this. And I don't see that competition authorities are doing a lot in the US either to eliminate such a cartel.
Yeah, no, I agree.
There were incidentally lawsuits against the potash cartel in the United States, must be 15 years ago, when there was a jurisdictional question raised and solved. But there actually, Fred made, among other things, this very important point that people are so focused on digital that this may be taking the oxygen out of the air for cartels before our eyes. I wanted to say one more word on inflation and competition, because this has been a hot topic in the news. And we know that inflation is extraordinary, like 7% right now. And as soon as, although this was somewhat gradually, but as soon as the severity of the inflation came home to hit us and people realized how severe it is, there was one group that said, oh, use antitrust will cure inflation by antitrust. So it turns out that this is not a good argument, that inflation is a macroeconomic problem and antitrust is microeconomic. However, the 2 points do have a relationship. So the claim is made, and I think is right, that we have many concentrated industries today, and in some industries, higher concentration. And in industries of higher concentration, you tend to see market power, more market power, and higher prices. And the higher prices can cause lower output. If there were more supply, that would tend to calm the inflation. It wouldn't solve the inflation. In addition, inflation has, in a way, it's called attention to antitrust, maybe irrationally because of the false immediately correspondents use antitrust and will get rid of inflation. But it has called attention to the fact that prices are too high and in many industries should be lower because of market power, not just because of inflation. And so this does give a spotlight to the antitrust authorities to say, yes, prices are too high in many cases in which it is a question of market power. And in some of those cases, we can do something about it with antitrust. You can't do everything about it with antitrust. Just because there's a market power does not mean there's an antitrust violation. It can be and should be that we're more aggressive about mergers in the meat industry, for example, which is one of the biggest tragedies of the high prices and the inflation. Somehow we've allowed huge concentration in the meat industry. Meat packing now, 4 companies have 85%. And prices are probably too high in meat, not only because of inflation, but because of market power.
Extremely interesting. Thank you.
Just one other point
Yes.
that Jonathan Cantor, the AIG, has made, which is that inflation has actually given cover to some cartels, because as inflation creates the environment of higher prices, where you do have a concentrated industry, it creates an environment where it's somewhat easier for those firms to just raise their prices within the cover of inflation and therefore accelerate the price rise.
Yeah, no, this is extremely interesting. Also, I should agree with Fred in the sense that actually the follow-up point I made on OPEC is not an apples to apples kind of a jump, because one is sovereign states, and that's a bigger bite to chew. Yeah. Yet the other one is basically, if you can go after the digital giants of the world, there's no reason why you shouldn't be able to go after this type of a structure too. Yet I wanted to jump on that OPEC point, because as Eleanor said, oil and fertilizers combined really do factor for quite a bit of the rise in the food prices, and you know, those two being tackled together could actually lead to a very significant improvement in at least food prices and the inflation, as much as it applies to food. Switching from oil to sustainability, the issue of competition law and sustainability, and I'm sure you would want to make your ideas known about whether sustainability is technically an objective that competition law can technically contribute to. It is quite interesting to me as well. I keep on debating this point, that as sterile as I try to keep the prime objective of competition law as welfare maximization, and we should target economic efficiency, I never try to exclude sustainability from that, because it is now a very clear part of the midterm welfare function, in my view. So when people criticize me as being inconsistent because I've always pushed away all kinds of goals from competition law enforcement, and I tried to keep a very focused and narrowly tailored goal for competition law, but now I'm happy to build sustainability in, I don't really feel that there is an inconsistency there. And really, I feel sustainability is naturally a part of the objectives of competition law. I'd be very glad to learn from the masters of this field. And so I'd ask Eleanor if you feel that there is particularly a hurdle in competition law integrating sustainability goals. And also, if I could ask, do you believe that we're at that phase where we're just paying lip service to it and a lot of talk about sustainability, but we do not actually see policy preferences being made in the competition law field for sustainability yet?
So that's a really important set of questions, especially because our planet is at risk. I mean, it is one of the couple of existential problems. And I've noticed with really great interest through the last, say, about 8 years, how sustainability values have become more and more mainstream in antitrust in the world, except not in the United States. So I want to make a distinction between what US allows and is doing and what, for example, EU allows and is doing, and some countries within Europe, like the Netherlands, being very aggressive to try to address sustainability. And I also want to say, and we'll weave this in, that there are some sustainability goals that are not at odds and are very integral with what competition law does in making markets work, and you can even say in making greener markets work better. There are compatibilities, and then there is another area where there really is a trade-off. And if you pursue the competition goal, you would not allow the sustainability project. And I think the area where there is compatibility, I think, is an area where there has been enormous progress. So let me start that issue by saying that there are many projects that can be done in the interest of sustainability that do not violate the antitrust laws. And I think that both enforcers and companies being advised should think that first. Not to think, oh, this is great for sustainability, we've got to get an exemption or argue the case for sustainability. But first, they want to do a joint venture, for example. They want to do a joint venture on R&D to investigate and perhaps bring to market commercially some greener friendly technologies. Most of this can be done without any antitrust problem. And it can be sloppy for an agency, as I've seen around the world sometimes, where exemptions are allowed to simply say, oh, this is a good deal, and they don't do their antitrust analysis. They ought to do their antitrust analysis, and they will figure out in most cases that the antitrust analysis allows the collaboration. Then there are those cases in which companies might decide on a sustainability agreement that requires a certain amount of investment that they would not do themselves. They would not do themselves because they wouldn't have the incentive to do it themselves, because everybody else will compete on price and outcompete them. And they believe they can do it only together, and doing it together is a cartel. I mean, this can be your chicken for tomorrow case, which was the Dutch case in which the chicken companies, poultry companies decided that they would not sell, and they would sell only chickens that were raised in spaces with lots of room and light. And that caused the price of chickens to go up, and they agreed to boycott anybody who would sell cheap chickens. That, of course, makes it anti-competitive, very anti-competitive, and people who want cheap chickens couldn't get cheap chickens. It looked like it was a progressive agreement. So, so there are a couple of questions here when you start the analysis. Are these poultry companies that really wanted to raise the price of chickens, and they wanted to keep cheap chickens off the market? And without the cheap chickens, they would get more market power. And then it would be what is called now a greenwashing deal, which is not really a pro-environment deal, but getting under the tent of antitrust as kind of a fraud on antitrust. So that's one question. There are a lot of these possible agreements where the companies are going to do things in the name of the environment when they're really doing it to get more power and raise price. Another way of looking at these issues is regulatory wise. If we really think that chickens should not be sold that have been raised in very dark, crowded quarters, why not have a regulation to take care of it rather than the companies taking it into their own hands? But apart from that, I mean, this all goes to say there's a lot of room to say there is room for antitrust. and there's suspicion on sustainability agreements. But apart from that, there is this space, and it's being created more and more. It's being created in Europe. It's now in a chapter in the draft horizontal guidelines that would say when companies get together and it's indispensable for their environmental goal, and a fair share gets passed on to consumers of that product, they are not caught by the competition laws. And it may be that there are very few agreements that will fit with that. Was it a necessity to get this beneficial agreement done? But we'll see. Turning back to the United States does not allow any leeway to be made for a non-market goal. So if it fits with the market goal, fine. If it doesn't, it's a problem in the United States. The enforcers could, as a matter of priority, not sue. Somebody could sue, private party could sue, and it would be a violation. It is definitely, in my view, it is the coming value to be thought about and to be considered carefully in competition analysis. And the way I said it, that should almost be clear. It should be thought about and considered in competition analysis. Would you allow me one more point that I just wanted to make? Mergers. And think Bayer Monsanto. I think there was a real sustainability problem in Bayer Monsanto in that this was consolidation of feed fertilizer industry down to just a couple of firms left. As you have a couple of firms left, it means greater, it means less in biodiversity and less resilience, which actually can be called competition problems. And I think when you think about the sustainability problems and you think first, what is compatible with competition and how can you talk about it as a competition problem, I think that would be useful. I think that the sustainability problems of Bayer Monsanto should have surfaced, and they apparently didn't in any significant way.
Fred, same topic on competition law and sustainability.
Okay, a few comments. First of all, I'm not sure that the chicken case of the Netherlands entirely fits the question of sustainability. So there's an issue of what do we mean by sustainability? If I take a narrow view, and I will talk only about economic sustainability and or environmental sustainability, the idea is that we want to make sure that the use of resources that we engage into doesn't lead to a depletion of those resources for future generations. Okay, so I'm going to stick to this. And this is, so it's a question of comparing today to tomorrow. It's a question of dynamic. And in competition law, we have not been very active on this front. We have had more of a static thought. How can we best allocate the resources today without thinking very much about the future? There's only one area of antitrust where we have dealt with the issue of the future is when we come to looking at agreements on research and development, or the risk that a restriction on competition on research and development is going to lead to a decline in innovations in the future, for example, in the Dow-DuPont merger. Okay. Now, let me start from a practical case. In September 2019, the US Department of Justice started an investigation in the behavior of 5 automobile manufacturers, which had negotiated with the state of California the fact that they would put on the market cars that would meet higher standards than the federally imposed standards for carbon emission. The Justice Department decided to go after them, presumably on the idea that this kind of agreement, if there was an agreement between the firms, which turned out not to be the case, but let's assume that there was one, this kind of agreement would increase the price of cars for people in California, therefore would reduce the consumer welfare, and therefore was contrary to the Sherman Act and the US antitrust laws. There are two ways to look at this agreement if it existed. There's first a question of knowing whether it was necessary to have an agreement, and presumably the answer is that no car manufacturer would have on its own created a more expensive car but a cleaner car unless he knew that the others were doing the same thing, because he would have been priced out of the market. Okay, so we can assume that there was a coordination issue. But the second is that from the competition angle, we can look at two things. We can decide to focus on the very short run. And in the very short run, indeed, we arrive at the conclusion that the Justice Department arrived at that I've just mentioned. But we can have also another look. We can say this agreement, if it existed, reduced the cost of transportation in California by leading to less undesirable consequences from this. And this is a cartel that reduces the cost and preserves resources. And from that point of view, it should not be considered to be anti-competitive. So I think that a big part of the question is, what is the time frame that competition authority use to look at competition issues, and that we could perfectly well include sustainability as a consideration by having a longer time frame to look at competition issues. And there's nothing in the theory that says that we have to look only at a very short term effect, and that we have to discount the longer term effects. I want to make a second point, which is the fact that Macon Delrahim was at the time the Assistant Attorney General in charge of antitrust in the US, made the point that there's nothing that can excuse a collusion between competitors. What is interesting is that he made this statement exactly at the time when, so let me read you the statement of Macon Delrahim. The loftiest of purported motivation does not excuse anti-competitive collusion among rivals. This is a long-standing antitrust law. What is interesting is that this statement arrived exactly at the same time as another statement by Macon Delrahim, which was the fact that due to the exigent circumstances of COVID, the Justice Department would not go after collusion between competitors who are trying to improve the supply of masks or respirators or whatever we needed at the time. And I think that this second position was quite right. The fact that there may have been necessary arrangement between competitors to better irrigate the market to make sure that the negative effect of the lack of respirators or the lack of protections against COVID justified the fact that we could accept that there was an agreement between them. But what I see there is that there are two different, somewhat contradictory analyses by the same person at the same time. When it comes to looking at an agreement which could conceivably lead to, to preserve resources, oh no, this is not acceptable. When he looks at a cartel or a collusion which might lead to reducing the cost of COVID, oh yes, that's acceptable. So it seems to me that competition authorities have two dimensions on which they can play. One of them is the time framework of their analysis, which could be a bit longer and allow for the possible positive effects on resources from some of the agreements which are necessary when there's a market failure. The second one is prosecutorial discretion. Competition authorities use their prosecutorial discretion, for example, not to go after cartels when there is a COVID crisis. They could use their prosecutorial discretion exactly for the same way when there are market failures that lead firms to come together to decide that they are going to do something which is going to be beneficial to the environment and to sustainability.
Wonderful. Thank you. This is really food for thought and soul too. Digital markets and competition law was going to be our next topic. I'm viewing the time. This is a very important topic, so we won't sacrifice anything on this one. But I propose that then we take on our number 4s and 5s together, which is we were going to discuss convergence versus national policy preferences, globalization and competition law on one hand. And as a separate topic, we were going to discuss public interest goals and the prime objective of competition law. I guess we can mush the public interest goals discussion into the convergence versus national policy preferences bit, and also discuss what public interest goals being on the rise does to convergence and globalization and competition law. Parking that to last, I'm going into the matter of, is there a monopoly problem, digital markets and competition law? Eleanor, I guess it is almost presupposed now that there is an issue with digital markets. And not that I'm going to negate this, but it has come to a point where now any merger, any acquisition, any transaction between digital players is taking a very long time in review. With some of them, I'm really lost to see the theory of harm. I'm trying to, wrap my head around the monetization structure there and how this is going to present an issue. There's a lot of scaremongering going on and a lot of speculative leaps of faith as well as to what might happen in the future. And it seems this is because of an analysis that is done in hindsight as to certain transactions that have been allowed in the past and that have actually created a mightier company. I don't want to restrict anything to the merger control sphere, but I'm truly interested in your analysis of whether you feel that we are choosing some successful transactions, looking at those successful transactions, and we're saying, wow, maybe there should have been a deeper analysis. This has led to quite a bit of market power. Next time we're going to be more careful. And then suddenly the Facebook Giphies and the Google Fitbits of the world are being hit by those images where actually there isn't much of an articulable theory of harm. Or am I just outdoing my line?
Oh, so actually you do make a very good point. And let me start though with the sentence not about the excesses of going overboard, but the problem.
Yep, please.
Because I think that most of the world thinks they do see a problem with the biggest of the big tech platforms having grown huge, having something that is regarded as market power, and it might not fit monopoly, and it might not even fit dominance, and is thought to lead to many abuses, some of which on the antitrust side, some on the privacy side, some on disinformation side, but a huge feeling out there that the biggest of the big tech, about 5 firms, have gotten control of us and our minds and our choices and our will and our data and are exploiting us, and that it should be controlled. I think Europe is certainly out front in this. UK is also individually, as is Germany, but so is Australia and several other countries. I would not say US is out in front, because US law that we have to deal with actually has a lot of conservatism in it. I think there is a very good claim that, let's call them the GAFA, have enormous power and have abused it in ways that both prevent competition on the merits on their platform, and that tend to prevent interoperability between their platforms and other platforms, creating a bigger moat and more market power, which is always enhanced by the huge network effects. However, I think that you are right that, Gönenç, that this concentration on big tech has led to a worry and investment of resources, for example, to examine many tiny startup mergers where one cannot predict today that that acquisition is likely to harm competition. I think that the craze was fueled by the fact that we now have a lot of Facebook documents that tell us why Facebook acquired Instagram and WhatsApp, for example, when they were tiny startups. And it was part of a strategy that Facebook had pegged them through very specific software, Onevo, as being in the pool of the next biggest competitors that they would have to worry about as thorns in their side. So it co-opted them. So acquisitions are therefore, along with monopoly dominance and anti-competitive agreements, acquisitions are also on the map. It's a balance. I mean, if Facebook and the other GAFAs are really acquiring all the startups that have a good chance of being the best competitors, that is a problem. On the other hand, it's sort of like a needle in the haystack in a way, because if you extend your merger review notification thresholds, for example, down to very low, the agencies have too much work to do, and they're fraud that is not going to give a payoff. And it may mean also that it might impair incentives even to go into the startup business.
Exactly. The exit being
exit,
less likely, basically would hit the entrepreneur behavior as well. Fred, not to derail you from articulating the problem or anything, but just as I asked a different angle type of a question to Eleanor, I'd like to ask you if we are moving away from market definition a little too much in the digital markets. Recently, I was a speaker in King's College at a panel, and people, except myself, seemed to agree wholeheartedly that market definition in digital markets is unnecessary, and one should concentrate on market power, and they can discern market power through behavior anyway. So what's the big deal with having to define markets? To which I ended up saying, well, market definition serves legal foreseeability, and these players actually do then understand if they are in a dominant position or not. And by the way, all agencies are articulating a market definition one way or another in their reasoned long-form decisions. So doing away with it is going to mean that they're going to arrive at a wrongdoing, and then they're going to reverse engineer a market definition to suit their primary goal of finding a violation. This seems like a bootstrapping exercise to me. I just wonder if you feel that market definition is too static and too archaic and is hindering the process of keeping digital markets vigilant.
Short answer is yes. And I'll give you an example which I've lived because I was at the OFT at the time, the Facebook Instagram merger. Why was it not blocked? Because everybody said, well, Instagram is a photo app, has nothing to do with the social media. They're on different markets, so there is no overlap. The problem is that in the digital world, one day you can be on one market, the next day with the same technology, the same algorithm, you can be on another market. So there is no link between the platform and a particular market, the way in traditional economy, there's a link between a production process and a particular market. I mean, the steel mill is very much attached to the steel market. I'm not saying they couldn't do something else with this technology, but it would be very difficult to adapt to producing, I don't know, plastic or something else. Whereas in the digital world, by definition, an algorithm allows a type of communication which can then be applied to many different services. And the fact that you're not on a market one day doesn't mean that you're not going to be on this market the next day. So the idea of relevant market is not as useful when we deal with digital market. And we see that, you know, Amazon, which started as a bookseller, has moved into doing all kinds of different things. Okay. So I think that this is one of the set of issues that we have, which is we do not fully understand. I mean, we could understand, but we don't fully understand how competition among platform works. And we use all categories that are very useful, barriers to entry and things like this, and potential competition, for example, because this is a consequence of the market definition. If you have the potential competition doctrine basically says that the potential competitor is somebody who is either already in the market or about to enter the market and could grow. Well, Instagram was not in the market for social media. That was clear, okay? And yet it was a potential competitor. That's true in the digital sector. It's less true in the real sector. But on the general point, I just wanted to make 2 points. So one point I've already made, which is the fact that we cannot use easily the traditional categories. We cannot use the price cost measures on markets where the price is equal to zero. It doesn't make any sense. We have multi-sided markets and not single-sided markets. So we have cross-subsidization between activities. So the notion of predation cannot be the same, et cetera, et cetera. So we have to adapt the tool to the digital sector and to the competition between digital platforms. And for this, we have to understand how they function and how they compete with each other. There's a huge business strategy literature on this, so we can learn fairly rapidly, but we have to change our tools to be able to be relevant. The second problem I want to point out is the fact that we are, in fact, talking about the data economy. And in the data economy, we have different layers of concerns with different objectives, and those objectives may be in contradiction with each other. The first idea that we have is the privacy of personal information and the protection of this privacy. The second one is ensuring the cybersecurity of data. The third one is ensuring the protection of consumers, which can be misled by the kind of information that they find. And finally, we have competition. Now, competition, as I said, is already difficult in itself. But when you mix it with the other consideration, you end up not, I mean, in the EU, for example, where we've had, every time we take a different text. I mean, for the privacy, we take the RGDP, and then for the cybersecurity, we have the directive on network and information system, and then for consumer protection, we have the DSA, and then for competition, we have the DMA. But all those initiatives are not linked with each other. But there are many cases where more privacy is going to lead to less competition or vice versa. And we have to think about those interactions, which leads me to believe that the UK proposal, which includes, among other things, the creation of a body of all the regulators of data to come together, is also a way to get much more consistency in our approach to the data economy, which is absolutely crucial even before we look at the monopoly problem.
On the point of consistency, I think this is a great segue to switch to our last topic, as articulated 4 and 5 amalgamated. So convergence versus national policy preferences with a touch of where does public interest goals being more and more integrated into competition law enforcement take us? There are some antitrust agencies that are really importing, I will say, a lot of policy preferences into the competition law field. Employment law goals, or rather employment goals directly, being one of them. In merger control, sometimes merger control reviews get, in my view, hijacked so that other commitments are provided by the parties. And interesting times are ahead of us in terms of a will to increase convergence, where national policy preferences are making their presence felt more and more as time goes by. This is a topic close to Eleanor's heart, I know, and she has worked on the national competition law regimes of so many different countries, and more holistically the emerging market regimes as well. So I'd like to give the floor to Eleanor for comments and last comments on this point of convergence versus national policy preferences and the effect of public interest goals in that.
So let me say that I think there is an ideal of more or less convergence, not absolute, and that can live well side by side many of the nation's adoptions of public interest goals. So when I think of what progress can be made on convergence, I think one useful cut to take is to say, look at the regulation of big tech and the diversity of viewpoints as to how much should be ex ante, how much should be ex post, what should be the overall guiding principles, and whether, what I'm going to say next might be drawing from you, Frédéric, whether there is a way to tease out at the highest level what our joint commonly agreed norms are. That whether there are principles that could, for example, be articulated in terms of, even if you've condensed it to big tech, X, Y, and Z is an abuse of power and should not happen. For example, squeezing a meritorious competitor off your gatekeeper platform because it got too good and too competitive, or imposing interoperability bars because you want to be more powerful. Some sorting out of norms at the highest level. And that can and should go on, and we should have more ways of talking about our common vision of what is good antitrust law. Then there is the question of, well, what about public interest, and the fact, as you've said, that many jurisdictions are embodying various public interests, and some, incidentally, are pretty compatible and market friendly with trying to make the market work better, but some are contrary to it. And some that are pretty compatible are, for example, in, at least to a certain extent, say South Africa, only to a certain extent, the goal of inclusiveness. The goal of inclusiveness makes you focus on exclusionary restraints and dominant firms creating barriers to entry. And South Africa is very focused on that, that if a restraint is created with no purpose, let's say, to make it easy, to make it very hard for challengers to get into the market, that is a big offense. So inclusiveness has a competition dimension. Then you have employment likewise. I mean, making your employment markets work better is competition law. Then you have various aspects that can cut against competition law. For example, some nations might want to protect small firms because they're small, although frankly, I think fewer are doing it now, protecting small firms because they're small. But firms countries do want to protect employees who are laid off by big mergers. And here, I simply think the nation ought to be counting the costs and recognizing the trade-offs, doing their competition analysis first. I think as we're moving into a world that has more regionals, I think countries that have unique and idiosyncratic public interest goals that cut against the market will be pressured not to do that.
This is very, very interesting. Thank you, Eleanor. And I'm happy that you brought South Africa into this, because I felt restrained this time, as I always use South Africa as an example. And I thought, you know, one day Tembi is going to think I'm just picking on South Africa, but their example is really flamboyant, as they do come up with quite a bit of negotiation power into certain transactions, and they actually request certain numbers of new jobs creation being committed. And while employment obviously is a part of competition and competition law, the technique with which it is done makes it very difficult to see if you know they're requesting things in a balanced manner, or with which parameters these are being balanced. It's more like to me, it's more like a hold-up item that you have to overcome, and if you commit that, then the procedure progresses. Fred, over to you on convergence versus divergence and the public policy preferences that are on the rise these days.
First of all, I basically agree with everything that Eleanor Fox has said, in the sense that I think that when you look at competition authorities, they show a high degree of convergence on the substance, even if they have, or they may have in their laws, public interest. They try to maintain or to, how would I put it, to make those public interest issues consistent or convergent with the basic principle of competition. But I think that, on the other hand, at a more political level, the competition community has failed, at least the politicians. They don't see that competition law is terribly helpful in developing, in other protecting ourselves against some issues, and there the digital sector comes to mind, or even at facilitating the development of the economy in such a way that is going to be innovative and productive. And from that point of view, the European competition law has been very active. Do we have a lot of innovation in Europe? Not so much. Do we have a lot of growth? Not so much. So there is a political push to try to overcome what is seen as something which is not terribly useful, which is the application of competition principles. And I think that this is at the heart of some of the public interest things, or public interest issues that we see. This is at the heart of some of the protectionism which is growing. This is at the heart of some of the provisions, for example, that apply to merger control, and which either tend to protect security or to protect against other firms that benefit from state aid and so on and so forth. So I think there's a bit of skepticism somewhere in the political world about the long-term benefit of competition. They can see the immediate result, but they don't particularly see that this helps developing the competitivity and the ability of countries to grow. And they are very concerned with this, where they see more in terms of political competition, so to speak. So that leads to a pressure to push more public interest issues, either in regulations or sometimes outside of competition law, but they do have an impact on competition law because they tend to restrict competition one way or the other.
Thank you. Thank you so very much, Eleanor, Fred, for 70 minutes of gem of competition law discussion and insight. I'm pretty sure the people attending have fawned even more than what they were expecting. And when the participants are figures such as your good selves, the expectations are never low. But as you always do, you have blown us away. Now, Nathan, I'm going to turn the platform to you, turn it over to you so that you do the closing. But once again, before I do that, I wholeheartedly thank Fred and Eleanor for their time and for the candid contributions that they've made. There is a video recording of this, and with their permission that I will try to get through separate correspondence, I will want to also make this publicly available so that young people can also benefit from this. These kinds of gigs, I think, are particularly important and interesting in the sense that it's very difficult for them to pay entrance fees into certain conferences and be a part of it. Yet here, thank you, Gillian. Gillian Sproul has kindly thanked both of you. I think these kinds of links are having an everlasting impact. When I look at the journey of these kinds of videos, I see really herds of young people going in and benefiting from it. Nathan, over to you, please.
I really want to thank all three of you for taking your time to speak with me. Frédéric, for example, after you were speaking on Potash, I ended up looking up, it turns out you gave a talk on a similar issue with Potash back in 2012, and I've been learning a great deal. Same thing with a lot of stuff that you've been talking about, Eleanor. It's been really informative. I think I've learned a lot, and I hope everyone who's listening has learned a lot too. I want to thank all the speakers, Gönenç, Frédéric, and Eleanor. Really appreciate everyone taking the time to listen, and thank you again for taking the time to speak with us.